Good evening and welcome. I'm delighted to welcome on behalf of the Stationers' Company both our speakers for this evening and such a very large audience from both sides of the proverbial pond, which rather reflects our choice of speakers this evening. So just a couple of familiar housekeeping points before we get started. We are recording tonight's event and you'll receive a link for this afterwards. And you will be able to ask questions through the Q&A tool function at the foot of your screen. Please use the Q&A section rather than the chat section. And we'll try and address as many of your questions as we can in the time we have left at the end of this session. Before I introduce our speakers, I'd just like to, I'm very conscious not everyone has a direct connection with the company. So let me briefly tell you something about its history and what it does. The Stationers' Company is the City of London's livery company that helps both individuals and organisations in the communications and content industries to improve their performance and their prospects. Our 600-year-old tradition, which embraces everything from the origins of copyright to the contributions we make today through education, training and charitable endeavour, combines conviviality with the enhancement of business and society. The company's roots can be traced back to about 1400 in the City of London, where it began as a trade guild to protect the interests of manuscript writers and illuminators. Unlike most craftsmen in those days who were itinerant, they set up stalls or stations, as they were called, around St. Paul's, and as a result acquired the name Stationers. The company is unique among the older London liveries, with active links to its modern trades, professions and industries. And out of nearly 1,000 members today, the vast majority are actively involved in paper, print, publishing, packaging, office products, newspapers, broadcasting, online media and design. If tonight's event inspires you or you'd like to find out more about us or are interested in joining, please do visit the website at stationers.org. And now I'm pleased to introduce our two very distinguished speakers. You have already got their brief biographies, so I'll keep my introduction even shorter and try and do justice to each of them. Shira Perlmutter was appointed the Register of Copyrights and Director of the US Copyright Office in October last year. She had been previously Chief Policy Officer and Director for International Affairs at the US Patent and Trademarks Office. Shira has also been responsible for policy and industry at the Record Industries International Federation of the Phonographic Industry, IFPI, based in London, and also at Time Warner. Shira received degrees from Harvard University and the University of Pennsylvania and is currently a research fellow at the Oxford IP Research Centre at Oxford University. Daniel Alexander QC has been a Deputy High Court Judge since 2006 and has chaired the Intellectual Property Bar Association since 2007. His academic and professional life gives him an international perspective of IP, having been awarded a first-class degree from Oxford in physics and philosophy and an LLM from Harvard Law School before being called to both the Bar of England and Wales and the New York Bar in the same year. So, without further ado, we're going to look at two very 21st century issues this evening and at how copyright law measures up to dealing with them. We'll take each issue in turn, allowing about 20 minutes for each, and then I'll open up the floor to questions from all of you. So first of all, we're going to look at the role and responsibilities of online platforms in the dissemination of news and other content protected by copyright. First of all, what is the role of an internet service provider Are they a publisher? If not, what are they? What responsibilities come with that role? We're going to be looking at some of these issues as we talk. So first, I'd like to take a look at what's actually happening in each of the US and the UK at this moment. And perhaps, Shira, I could start with you. And if you could tell us what's going on, maybe with the DMCA or anything else that's relevant.
Yes, thank you, Sarah. Delighted to be here. I'm only sorry that I can't be in London in person seeing old friends. There has been a lot of attention paid to this issue in the United States over the last few years. I would say at least the last 10 years. As many of you know, it is Section 512 of the US Digital Millennium Copyright Act, or DMCA, that sets out various safe harbors that are available to online service providers against liability for the transmission or hosting of infringing content. And first of all, there's been a lot of attention paid in Congress. So there have been a number of congressional hearings that many of you may have followed or participated in. Almost 10 years ago now, the Department of Commerce issued a green paper that described some of the strains after 20 years of evolution in the marketplace and in technology since the law was passed in 1998. And just a few months ago, well, last summer, the US Copyright Office, where I work now, issued a study based on extensive input from the public and analysis and research about Section 512. And the conclusion of the study was that the balance that the law intended to create had become skewed after 20 years of interpretation and operation. The law was originally intended to establish a cooperative system where right holders and service providers work together to control infringement online. But the Copyright Office found in this report that that was no longer the case. The balance was no longer in place. And essentially, the input from the public showed that one side of that balance, the service provider side, was satisfied with how it was operating, but the other side was quite unhappy with how it was working. Now, the office identified a number of steps that Congress could take or could consider taking to rebalance this approach. And that included taking a look at and possibly revising the knowledge standard in the law. When I say the knowledge standard, I mean the actual knowledge or red flag standard contained in the statute that if a service provider meets that standard, they cannot take advantage of the safe harbor. The report also suggested a look at the contents of a valid notice, what a right holder had to provide to a service provider in order to get content taken down, and improving or enhancing penalties for abuses of the notice system, whether by a notice provider or in a counter notification. And the office also recommended a number of non-legislative approaches. So since the report came out, the office has created a web page dedicated to the DMCA, which provides a lot of helpful information, and also has held a series of roundtables on standard technical measures. And these are mentioned in the DMCA. They're foreseen as an approach to helping to control online infringement, and that is to the extent that standard technical measures are adopted by a wide range of stakeholders, then service providers would have an obligation to accommodate or not interfere with them. That part of the statute has never been invoked. There are no measures that have been identified as standard technical measures. So we held roundtables to talk about how that process might work. So the current status is that Senator Tillis, who was until the last election chairing the IP subcommittee in the Senate, the subcommittee of the Judiciary Committee, he had circulated a discussion draft, what was called the Digital Copyright Act, last year. He asked for stakeholder comments by the end of last week, which I gather have now been submitted. And he is now the chief minority representative, now that the Senate control has shifted to the Democrats. But he has announced that he plans to introduce a bill addressing these issues and taking into account the stakeholder input in April or May. So we will see what happens at that point. And Senator Tillis has also said that he hopes that the platforms can come to the table with right holders and that some voluntary measures might be put in place. But if that does not happen, then he will be pursuing a legislative solution.
Thanks very much, Shira. Perhaps we can come back to the voluntary versus legislative in a bit. And so the balance clearly isn't right. Where is the balance not right, or how is it skewed? Can you tell us a bit more about that?
Well, I would say the chief complaints from the right holder community have been that primarily focused on the fact that what they sometimes refer to as the whack-a-mole problem, that as soon as content gets taken down, it may be reposted again, sometimes in the same place. And so it becomes extremely burdensome to deal with that. You cannot be constantly providing new notices for the same infringing material. The other main complaint is that it is, with the volume of content that's available these days online, it is very difficult, especially for smaller right holders, to police all of the internet and to bear the burden of finding infringement and bringing it to the attention of service providers. And the sheer volume is something that was not even contemplated in 1998. We thought we had a lot of content then, but little did we know how it would multiply.
Daniel, before we go on, could you sort of tell us a bit about where you think things might stand in the UK? I mean, we don't have the benefit of a DMCA, and I don't know if you can comment on that.
Well, the news from the UK is really more noteworthy for the absence of news than the presence of news in this particular context. As you'll all be aware, the DSM directive, which was one of the most controversial pieces of intellectual property legislation in a field quite rich with controversial pieces of legislation, is due to be implemented by other EU member states later this year. And there is an extensive program that the Commission has embarked on for assisting member states in implementing the directive. That, for those who are less familiar with this issue, contains a number of important provisions, including on text and data mining, to permit those, to provide certain exceptions for cross-border teaching, for making provision for exceptions for cultural heritage, and importantly, in the context of the liability of online platforms, provides for rights for particularly press publications established in member states where there is online use by information society service providers of those works under certain conditions, and where non-commercial uses are permitted. The other important provision, which links with the discussion that we've just had, is that there is a provision in Article 17, which has probably been the most controversial of all of the provisions of the directive, requiring member states to provide essentially an amendment to their copyright laws and an amendment to the existing EU regime regarding the acts of communication to the public, where it will be regarded as an act of communication to the public, or an act of making available to the public when access is given to copyright protected works or other protected subject matter uploaded by users, subject to somewhat more limited defenses than are available under pure safe harbor provisions, including particularly that online content sharing service has got to have made best efforts to obtain authorization for use of those rights, that they have to be in accordance with high industry standards of professional diligence. Best efforts have got to be made to ensure that there is appropriate authorization, that they've acted expeditiously upon a notice requiring takedown, and those are to some extent, or the extent of the obligations are proportionate to the size of the undertaking in question, and there are slightly less stringent obligations for somewhat smaller undertakings. It doesn't provide a general requirement for monitoring, but one of the controversies, obviously, that has existed in relation to that provision is the extent to which that requires a degree of filtering, and how that ought to be achieved. As regards the United Kingdom, the UK government has said that it's not going to implement this directive, although it was in fact a supporter of it at the time in 2019 when it was passed. The reasons for that have not been given in great detail, but the issue remains an open one for what the UK should be doing post Brexit. One of the big issues, of course, for copyright policy is, in the words of the old song, "Now we have found freedom, what are we going to do with it?" It's an adaptation of the old song. And one of the things, of course, that we are doing with it is not doing things that we'd otherwise be obliged to do. And this is, of course, one of them. There are, as you may be aware, other provisions as well of that directive. It comes as a package. And one of the sets of provisions, which is no less important, relates to the obligations to provide fair and appropriate remuneration when authors and performers license or transfer exclusive rights for the exploitation of their works to those who are exploiting them, providing a kind of general remuneration right. And one of the advantages, it might be said, of not being within the EU is that it gives the United Kingdom an opportunity to pick and choose which of the approaches of alignment it wishes to take, whether it would wish to take a completely aligned approach with respect to the online service provider liability, or whether it would take a more comprehensive approach. So that's where we are now. And I don't detect, though, and others may know more than me on this, that there is a huge push on the part of the government to try and sort this whole area out urgently. In fact, on the other issue on the agenda, AI, there has been a greater degree of at least consultation with the public as to how matters ought to move forward. This seems to me very embryonic business for the post-Brexit agenda.
Thanks very much, Daniel.
I should say, I didn't say it right at the outset, thank you so much for inviting me here. It's a particular pleasure, I just wanted to say, to be here, because my mother was a solicitor in a publishing firm. In fact, her first work that she had to do was on the Lady Chatterley case to defend it from an obscenity charge.
Right, what a pedigree. It's very interesting that we're at this crossroads in the UK. You've obviously got the DMCA being reviewed in the US, and we're seeing a huge effort now sweeping around the world to try and do something about the platforms, bring them to account in a number of different ways, but particularly in relation to their usage of copyright content and the dissemination of news as well. And I mean, I'd just like to ask you both, do you think copyright is the right tool? Because we've got, I think half the member states in Europe are actually really struggling with implementing this directive. We know how controversial it was, but they are trying to find a solution through copyright. We have seen this showdown in Australia between the government and the platforms over, but they've introduced a code under competition law, so their approach is quite different. Canada today announced it was going to introduce 2 bills to regulate the use of the payment for news content. So there are different approaches. I mean, is copyright the right way to go? Is it up to the mark? Can it deal with this? I don't know if one of you would like to comment on that.
Well, I might just start by saying, I think copyright and competition law both can play a role. They both have different policies and goals behind them and different tools at their disposal. It seems to me that in the copyright sphere, a lot of the difficulty in dealing with this, including in the implementation of the directive, is the problem in trying to reconcile the effectiveness of technological tools that might be available to control infringement with making sure that you can accommodate balance and fairness in the law through technological tools. And also, of course, just the burdens of who is going to have to pay for adopting whatever tools are put into place. So those difficulties may be there in whatever the body of law is in terms of ensuring balance with effectiveness, and on the other hand, dealing with the politics. But it does seem to me, I'm not at all an expert in competition law, but competition law can be very useful in dealing with the particular situation where you may have market dominance combined with some sort of abuse of that position, whereas copyright normally would apply to all types of players at all levels. So they seem to be directed at very different kinds of ills and to each have an appropriate role to play.
Thank you. Daniel, I don't know if you want to comment on that.
Yes, very briefly, I entirely agree with what's been said. There seem to be 2 things that competition law can bring to the party here. First, it can be effective at regulating terms of licenses. And one sees that in a whole range of contexts. It might be said that for example, the Copyright Tribunal itself is to some extent a competition tribunal. It was established within a framework for settling fair and reasonable terms. Competition law has had a considerable impact, not just in copyright, but also increasingly in patents, where you see collective licenses for the underlying technology, setting a framework for the licenses that can be fair. The other area that it has importance is in ensuring non-discriminatory carriage of content, and ensuring that in particular content isn't booted off platforms because there is a desire not to compensate the supplier of the content for the use of those works. So those are twin aspects where competition law can do things which copyright law really can't do, but which the system as a whole needs to do if there's to be both fair licensing, fair control by proprietors, and non-exploitation by those who are actually making significant money out of the presence of copyright works.
It's fascinating. And we're also seeing, particularly in Australia, we saw deals struck with the larger players, News Corp and others. And you get the sense that the foot's been taken off the pedal a bit. What happens to the smaller players? How can they be protected, the smaller news disseminators. Is there something else that should be done? I mean, does the Australian model not work for that reason? Is it essential that we have our copyright solution, a collective solution maybe for all? Would one of you like to comment at all?
I mean, I would just say it is important that there be a solution that can include the smaller players and not just those with the clout to negotiate very large agreements. What the best way is to do that, I don't know. Perhaps a collective solution is the answer. Daniel, what were your thoughts on this?
Well, I agree. When I first read the Australian law, I was actually quite, I wouldn't say shocked, but a little surprised that there were these cutoffs essentially as to those who were entitled to participate in the system in that way. And one can understand the rationale. Some of them are not just size of business, their regulatory status and so forth. So it is not a criticism of the law, but it was a surprise. One of the things that one can sometimes do in this kind of context, and funnily enough, is provided for in the context of some of the other provisions of the directive concerning the approaches to collective licensing, is to say, well, if we, the big boys, if I can put it in very colloquial terms, are going to get a good deal for ourselves in this kind of context, then the terms should also extend to others in the industry, not just those who are particularly well placed to negotiate those deals. So the model there is more a kind of traditional collective bargaining or trade union model, where the terms that are negotiated by those who are particularly powerful will then extend across the whole of the industry. But I find difficulty with systems that only apply to those market participants of a certain size. There's one other remedy though, and this is a procedural issue, just to mention it, because I know you wanted to us touch on it, which is in some contexts, it's possible to set up what might be called class action or similar kind of claims. And if those can be set up in a sensible way, I mean, one sees it almost automatically in a copyright licensing situation by licensing schemes and so forth, which are then applicable across the board to the whole industry. That can sometimes solve those sorts of big person, little person issues.
And Shira, do you have experience of this in the States at all, or is this something that might be being looked at? So more of a collective approach, or?
To this particular issue, not that I'm aware of, no. I mean, obviously, in a number of areas in the entertainment industry, there are collective organizations, there are unions, and that is a very useful function to ensure that, as you might say, the little guy is able to be adequately represented. For this particular purpose, I am not aware of those discussions going on at this point in time. Doesn't mean it might not be a good idea.
Yeah, yeah. And then, Daniel, did you want to say something more about enforcement and remedies?
Well, it just links with what I was saying earlier. I sometimes think in this area, even providing an enforcement mechanism creates a kind of framework within which people can and then will do negotiated deals. So having some time ago done quite a lot of copyright tribunal cases in this country, the very fact that there is a copyright tribunal which regulates the terms of collective licenses is something that brings people together to force them to do deals consensually that they otherwise wouldn't really be thinking of doing at all for one reason or another. One goes back to the Australian scenario. One of the issues that I think was causing consternation on the part of the platforms was the fact that the Australian law not only sets up a mechanism for negotiation, it also sets up a mechanism for a very specific kind of essentially last chance or best offer arbitration, where the idea is that each party will submit their best proposal, and the arbitrator doesn't have a choice, as the Copyright Tribunal does, of saying, well, I don't like either of your proposals. I'm going to craft my own in relation to licenses. There's a binary choice. You either take one or the other. So the parties have got to try and pitch their offer to be the one that is most likely to be accepted. And certainly from experience of litigation and so on, quite often the very last thing that parties want is to have a deal forced upon them, particularly a deal of that kind. And so the very fact that you set up this kind of mechanism that says, well, if you don't do a deal yourselves, this is the nightmare that faces you, actually forces the parties to do something in that framework, which then makes sense. And one of the interesting things may be that it doesn't just make sense in the context of a particular country or territory. So one of the things that we see, for example, in patents is that the presence of a kind of patent infringement collective licensing mechanism for mobile telecommunications patents sets up a framework within which parties then know that they really have to do deals. And my sense is that the wise legislator looks not only to dispute resolution mechanisms being genuinely dispute resolution, but also looks to them as being dispute discouraging mechanisms or deal encouraging mechanisms. And I thought that the Australians actually were quite canny in almost the game theoretic approach that they took to the litigation and resolution structure. And while I'm not an expert in that, I could see creative thinking in that area on enforcement actually delivering some results in this area.
So would you say on that basis that a voluntary approach, sort of a code, is going to do the trick, or does there need to be legislation backing it up?
You know, I think that's probably an empirical question, in the sense that we can look at the world and look to see where deals exist of the kind that one would like to see. And then one can look again to look at the legislative framework and ask, well, what was it that really prompted that to happen? Now, I am not enough of an expert in the sort of economics of this area to know whether there are reliable examples of industry deals that take place in a completely voluntary context. Obviously, there are in some areas, but it's not really completely voluntary, and that if you've got an underlying exclusive right, then there's the threat of an injunction at the end of the day for some contexts. But if one's merely saying to very substantial undertakings, you know, you ought to act in this way, it would be kind of nice if you did, I am not sure that's that effective, because there are always good reasons not to. And one of the good reasons not to is if one does X in this way, it sets a precedent for another jurisdiction. And so I don't know. I would be very interested to see what the global studies are on voluntary as opposed to constrained voluntary. And it may be that the United States, which has phenomenal data analysis on this, is the place to look, or a place to look.
Yes, Shira, would you like to comment on voluntary versus regulatory? Or...
Well, you know, one thing I was thinking of mentioning, it's not exactly on the issue of voluntary versus regulatory, but on the issue of remedies being available to participants in the system of different sizes. One of the developments in the United States that we're the most excited about at the moment is the establishment of a small claims court for copyright disputes. And I know that has existed in the UK for a while. We're new to this party, but we're very actively involved right now in putting in place all the regulations to set this up as a means to make sure that everyone, whether it's an individual or a business of a very small size, has access to a system that allows them to establish rights or defend against claims in a way that is accessible and affordable. So I would mention that. In terms of voluntary and regulatory systems, obviously the US and the UK are quite different in various respects in terms of the legal structure. We administer in our office a great number of different regulatory licensing systems. They seem to work well, although it can take a long time and be expensive to make changes and to operate through the system. But obviously, doing further economic analysis would be a good idea. And toward that end, one of the things that we were about to do is to hire a chief economist for the Copyright Office so that we can engage in those kinds of studies and that kind of analysis. So I'm looking forward to having that capability.
Sounds good, yeah. Essential. And lastly, before we move on to AI, are we right to continue with a very territorial approach to solving these massive online problems, which are global? Is that going to work, or do we need something more global, more international as an approach?
Yeah, I mean, this is a question we've obviously been struggling with for some time, especially since the development of the online marketplace. So really in the last 20 years. I think the idea of having a single harmonized international approach to any particular copyright issue is always a very appealing goal in theory. But there's a lot of reasons why it's not always achievable, or at least not always achievable at once. So of course, there are differing legal and cultural values in different countries. There are differing political and economic contexts that always have to be taken into account, although to some extent we're seeing more convergence than before. But the problem is that international instruments are not easy to negotiate. They usually require consensus, particularly if they're done at WIPO, and they take years. I mean, the fastest we've seen, I think, was the Marrakesh Treaty, which still took about 4 or 5 years from beginning to end. So what generally happens is first you get a coalescing body of law at national levels, at least in a number of major markets, and then the treaty or the idea of a treaty can emerge from that coalescing body of law. And then once, of course, the treaty is concluded, it has the advantages of harmonizing, it has the advantages of binding those countries that join it, and it also has the advantage of serving as a template for national laws in those countries where they don't yet have them. So it's a long process, it's a slow process. It can be very beneficial, but I think we have to recognize as a matter of reality that we're going to have to start at national levels and move from there. But I would say just one more point. I think what's really critical to the functioning of global markets is that even during those time periods where national laws exist and are not identical, the critical question is whether they're compatible. I used to use the word interoperable until I realized that that had too much baggage attached to it from the past. But the question is, how do we make sure that businesses can operate efficiently across borders and across oceans while complying with the law in each of these jurisdictions? And we don't want our differences to serve as an unintended barrier to trade.
Yes, we're experiencing barriers to trade at the moment. Daniel, do you want to comment on the...
Well, I agree with all of that. I think with some of these very new questions, it's important to start with examples that work in local jurisdictions before trying to create a completely international model. For all the reasons that have been given, doing a purely top-down exercise is very difficult. It's also not clear that doing things locally, even if there are slightly different approaches taken in different jurisdictions, is that much worse than trying to do things on a fully harmonized basis. And I think one can even see that in some of the consequences of the Australian decision. I'm not quite sure what the terms of the agreements are that have been reached as a result, or the approaches taken, but I would be surprised if an approach taken in one jurisdiction wasn't effectively by contract then extended further to other jurisdictions. Obviously, that doesn't happen in all contexts. If we go back to the Copyright Tribunal context in Europe, there are copyright tribunals which settle rights locally for individual countries. That's actually been perfectly satisfactory in many respects. And indeed, the United Kingdom courts have said that the UK Copyright Tribunal can't settle terms for other countries. It doesn't mean that the system overall is not a properly functioning one. It's not ideal, it's not a one-stop shop, but there are also issues of cultural respect. So one of the disadvantages of having a completely unified system is it means one can't adjust rights and approaches reflecting sensitivities in particular markets. There are some areas where there'll be more concern, for example, for limitations on, or alleged limitations on, freedom of access, freedom of speech. One can adjust those a little bit in some markets. And I think that going for gold in this context is not always the optimum strategy.
So it's going to be iterative at the very least, and country by country. Well, let's move on to the topic of artificial intelligence. AI is already well embedded in many day-to-day aspects of our lives, but its application to producing synthetic works such as music, ostensibly music, poetry, images, articles. There was an article in The Guardian last year. This really raises challenges for copyright, or does it? Obviously, producing an AI work has a beginning, a middle, and an end. And the beginning is the creating the code to tell the machines what to do. In the middle, you've got thousands, hundreds of thousands, millions of works, pieces of data, pieces of information that the machine studies and learns patterns from. And then it spits out at the other end whatever it is the code maker wanted, whether it's a piece of music that sounds like a Beatles song, or a piece of poetry. So these are all the different things that have to be considered in the different stages of AI. And I just wondered, first of all, Shira, if you could tell us a bit about what the approach to AI is in the States at the moment. And
yes, absolutely. We've been doing a fair amount of work on this lately. We've partnered with WIPO and putting on a program on the impact of AI on copyright. And we've also been working with the Patent and Trademark Office, which is looking at all of the areas of IP. To begin with, it's clear in this country that works that don't have creative input from a human being are not copyrightable. And that is established in our compendium of Copyright Office practices, and the courts have said the same thing. The famous case is the one that dealt with a monkey selfie, where the courts agreed that it was not protectable by copyright. So that is regardless of how creative the monkey might happen to be. And I should also make the point that we've also refused registration and do refuse registration to works created through a automated process of transforming a work in some way. So that is fairly clear. The issue in the United States, as I think elsewhere, is more complex and more interesting, is the question of the input or ingestion of copyrighted works for purposes of machine learning. And there, under US law, the key question is whether it qualifies as fair use. And I think most people are familiar with the way the US fair use doctrine works, but it does require the balancing of multiple factors and is extremely fact intensive. So it has the benefit on the one hand of being very flexible and adaptable to new circumstances, but on the other hand, it also can be less than fully predictable. All of the issues involved with the ingestion of copyrighted works for machine learning and for the development of artificial intelligence, these issues have not fully been considered and resolved yet by the courts, not surprisingly, because that takes some time. But I think it's fair to say that in at least some cases, this type of activity will qualify as fair use. And that will most likely be where the reproductions are made technically for purposes of internal use only, and it's not being done for commercial purposes. But I mean, that means that probably the results will often be very similar to what the results would be under UK or EU law, but not always. So we shall see. And one thing I will note is that the PTO issued a report that summarized input that they received from the public on these issues. And one point that was raised in that report is that a number of people were suggesting that appropriate treatment would be to say, at least if it's not fair use, that permission should not be required for this activity, but that there should be some way to compensate the right holders. So we are continuing to work on these issues and to consider them, and we are planning to organize a public event with the US Patent and Trademark Office later this year that will focus specifically on these input issues rather than the output issues.
That's very interesting, and perhaps not dissimilar to what we're doing here in the UK. Daniel, would you like to talk about the UK?
Well, at the moment, the UK IPO is in the middle of analysing responses to a consultation that it issued last September concerning AI across the board in intellectual property. So looking at some of these copyright issues, looking at patents in probably even more so. I don't think there's a legislative program in contemplation at the moment, but there are certainly some areas where the UK IPO has been asking for views. Focusing on copyright to begin with, we have a somewhat different approach to that of the US, in that we have had for a considerable time a provision in our law that relates to computer-generated works, which provides for copyright protection for such works, and the author is the person by whom the arrangements necessary for the creation of the work are undertaken. That hasn't received a great deal of attention in the courts. There was a case some while ago called Nova and Mizuma, which related to designs for the layout of video games, where essentially what happened was that a human designer designed parts of the game, and then the computer created the game from the particular elements that the person had designed. And the court said, well, that's at least in part a computer-generated work, or potentially computer-generated, potentially the subject of copyright protection. So that is not a difficulty that we have really had to face so far. The area where there have been difficulties, albeit recently resolved in the courts, have been on patents on the related line, where the High Court rejected an application for a patent which was made very expressly on the basis that it was not an invention made by a human being, but was an artificial intelligence invention, and the human person who was responsible for the software disavowed any claim to the invention on the basis that it was an unprincipled claim for him to have made, when in fact it was, he said it was the computer who generated it. That patent was rejected on the footing that the English statutory regime requires there to be a human inventor. But interestingly, the court, although firmly rejecting that approach, said that it was potentially arguable in other cases that an analogous approach to that in copyright might be acceptable, that if one could argue that the inventor was someone who had essentially created the machine to do the creation, that was not something that could be ruled out. So that is an issue that is currently under consultation. A related issue, which is perhaps just as important, are the conditions under which both copyright and patent protection would exist in artificial intelligence. On copyright protection, we are currently under the European regime of requiring originality to be a work of a person's original creation, and no one has really worked out exactly where the boundary of that lies. I don't think that is likely to be a particular difficulty, but it's one that is under review. And finally, in this area, there is a debate about the extent to which protection should be granted for essentially works of artificial intelligence. That affects patents again more than copyrights, because computer software is protected in the ordinary way by copyright, so that doesn't give rise to a question of a particular difficulty. It does give rise to some questions of difficulty in the context of patent law. And in fact, the last case that I decided as a deputy judge was, I think, the first case where a invention that was expressly said to be an artificial intelligence invention came to be considered as to whether it was excluded from patentability as being more than a computer program. And I upheld the decision of the controller that it was excluded from patentability on the basis that it was a computer program as such. But it is possible that other inventions in that broad field will receive somewhat different treatment on different facts relating to the contribution. In the UK, we have not yet had to grapple with the issue that was just mentioned about use of use by artificial intelligence of copyright works. My suspicion, though, is that it may turn out to be an easier issue than it at first appears, because it is usually possible to identify someone essentially putting in motion the act of copying. The big issue, as has been identified, will be one of fair dealing under our fair dealing laws, which, as you know, are somewhat more restrictive than the ones in the United States.
Yes, I was going to come on to that, Daniel, and ask you, what about all these works that are being used for the deep learning? I mean, should there be compensation? Should there be licensing? Or, I mean, the fair dealing regime here is much narrower, but it seems that, none of this could happen if the machines couldn't learn from a huge body of work, a huge body of data. And surely the people who created that in the first place are entitled to some reward, as they would be under copyright law normally. Or is this an example of, I mean, if there's a commercial end result, then it wouldn't fall under any sort of text and data mining exception.
I mean, the problem with it is that it wouldn't fall under that exception insofar as the original use was not authorized, which may go back to the original question as to whether or not there was fair dealing for one of the statutorily provided purposes. If there was if there was commercial use of a wide range of copyright works in order to produce a better machine, better learning machine, then it's difficult to see why that would be excluded from ordinary principles of copyright law. But I agree with what's been said, that at least a practical solution, or a solution more generally, is to think about how licensing schemes can be set up to provide for compensation in cases where it really matters that there should be compensation. Mm. So one of the things about the directive, and indeed patent law, is that, or it is UK patent law, is that it provides for compensation where there is a real benefit. What one perhaps does not want to do is to require so much pre-authorization to take place that it results in the machine learning not taking place because people can't get the rights together that they otherwise need. So I think there may be a case for a sui generis compensation scheme rather than requiring every individual item to be accounted for in advance. But that's really a policy matter. It's well above my pay grade.
Sounds like a role for collective licensing to me. Then I would say that, wouldn't I? And what about, with ownership and come responsibilities? I mean, are there any, is there any way of enforcing? Well, I suppose if you're saying that the end product, the output, is not protected by copyright, the question doesn't arise. But if it is, how do you go about sort of protecting that work and enforcing the rights that may exist over it? And who does that? Who is the owner of this synthetic work? Is that going to be a problem, or are we going to deal with it by saying it shouldn't be protected by copyright anyway, so the question doesn't arise?
Yeah, I mean, in the US, I don't think we would analyze it separately. The owner, the creator of a copyrighted work, the author, is by definition the owner. So if there is a human creator, that would be the owner, subject to any, obviously, agreements to transfer the rights.
Yeah.
I think there's also a traditional analysis of this problem, which is that there are many works that are new, original, creative works that rely on or have input from the works of others. And so long as the work is a new work, it doesn't give rise to problems of ownership of copyright in that work. Where I detect that there may be an issue, and again, this is probably more for the economists than for the lawyers, is having a regime that is so protective in advance that it dissuades people from doing machine learning works, where really what one wants and what those people putting input into those new works want is not to stop that work from being created, but simply to receive compensation if it turns out to be a success. That's the issue with a lot of these collective licensing problems. They're not the classic copyright problem where you want an injunction to stop your rival producing a product that is exactly the same as yours. This is usually a situation where you want someone else in the creative chain to use your work, certainly, but not to be cut out of the deal. Mm. And that gives rise to a different set of institutional and economic issues. And again, I think that requires sophisticated solutions, possibly to do with collective licensing, possibly to do with fair use plus compensation schemes. It's more in that terrain that I think future directed solutions are likely to be found.
So before I open everything up to the floor for questions, we've got some questions coming in, so please do remember to put your questions in the Q&A section. We'll come to them in a moment. Just having asked the question in relation to platforms is, I think the answer is pretty clear, but the territorial approach, the territorial copyright approach is probably the right one for AI, notwithstanding that, you know, the body of works that are being learnt from by the machine might come from all over the world. Does that cause a problem, or can we stick with our national copyright approach?
Yeah, I would really give the same answer. It's hard to see a much realistic choice that we not do that at this point in time, which doesn't mean ruling out something else later. And obviously questions about choice of law and applicable law, especially on ownership as well as use, will be critically important here as well.
I think there is another sort of second order problem, which is what exactly the AI system is doing and using. It's one thing to teach an AI system to do X using works A to Z. It's another to have an AI system that not only learns that, but also has in storage works A to Z continually, from which it continually takes data. Because it might be said that those are two very distinct situations in copyright. And one could envisage some artificial intelligence applications being in the former category, where really you just learn and then the work is discarded, the derivative works, sorry, the works from which the AI is derived are discarded. And there are others where you definitely want to retain the resource. So let's think about a chess computer. What you want to have a bank of historical games. You don't just want it to teach it to do things in general terms. You're going to want it to remember a whole lot of plans and possibly sort through them for an optimum strategy for any given move.
Yeah, another example that a colleague of mine used to give was a computer absorbing every single popular song ever written, and then creating new popular songs with knowledge of what went into making something a popular song, but not drawing on any one popular song as compared to another. How is that different from what every human composer does? And that's not the same situation where you need to retain them in some way, and or where you can draw a very clear link from any particular input to the output.
And now I think AI is, I was hearing yesterday, it's so advanced that you just issue an instruction or a prompt and the answer will come out without having to go through all that learning process, because as you say, it's banked up, it's done the learning, it's just there, and it's all becoming the new order, really. It's quite advanced. I'm going to open the floor up to questions, and the questions that we've got so far are going back to our discussion on the platforms. And first of all, Laurie Kay has a question for you, Shira. Do any of the proposals require or encourage any obligation of the platforms to take active steps through technology to filter, monitor, or check for infringing content?
Yes.
We didn't talk about filtering particularly, so I just wonder if you'd like to comment on that.
Yeah. Well, this is clearly the hot button issue for any reform to the DMCA or comparable laws in the UK or elsewhere. The discussion draft that Senator Tillis had circulated of the Digital Copyright Act included what you might call a notice and stay down requirement, where in particular, for complete or near complete copies of works, the service provider has to ensure that the content stays down, or if it's...
Yeah, you went on to mute.
Sorry, I went to mute by accident. The service provider would have to ensure that the content stayed down for complete or near complete copies of works, or if it had been notified before. So that arguably would require some type of filtering. The other aspect of the discussion draft would have required the Copyright Office in consultation with the National Institute of Standards and Technology to develop standard technical measures that service providers would have to accommodate and not interfere with. So that could include something that involved filtering as well.
Right. We then, Daniel, please feel free to come in if you want to say anything about that. Michael Clark points out that when governments don't push, it invariably implies the problem is too difficult. With a tsunami of data and proliferation of platforms, can current copyright processes cope, or are we just moving the deck chairs on the Titanic? It sort of goes back to what we were talking about earlier. But any thoughts on that one? I guess we have to start somewhere.
Should I kick off with that and the most recent question about pushing copyright initiatives?
Yes.
I mean, I don't think that there's at the moment a great appetite for pushing any of these initiatives. My point was more that insofar as there is activity in this area, it seems to be more on the AI front than it is on the platforms front. It's not clear to me at the moment that the government has a sort of overarching IP policy or is looking particularly intently in this. And the question that was asked about not pushing it, it's too difficult. Yes, it is too difficult, but it's one of those things that may become easier, because one of the things that will happen this year, apart from one seeing how, for example, Australia will play out, is that during the course of the year, different member states will be doing implementations of the DSM directive. And it will be possible to see how they work, what the resistance is, and so forth. And so being able to take that data set, say, well, actually now we can see how there's different implementation in different countries. Should we be starting to think about this ourselves? It may turn out that thinking about this, not this year, but next year would make sense.
Yeah, I would add, I do think there are things that can be done. I don't think we're just pushing deck chairs on the Titanic. And I think there are technological solutions that will come into play. I do have confidence in that. There has been some resistance to adopting them in the past. We are also watching with great interest how things evolve with the implementation of the DSM directive. And to the extent that service providers put in place new technological solutions into their services as part of their services, that may also affect where they're willing to go outside of the EU as well. So I think there are grounds for optimism on this. And I think trying to see how further voluntary solutions can evolve will in turn have an impact on the government and vice versa.
It's interesting. I mean, time, yes, things do change over time. Mark Seeley points out that the Google Books case was an attempted class action settlement. And to Daniel's point, but ultimately it was held to be overly ambitious and presenting antitrust problems. I don't know if either of you want to comment on Mark's comment. Laurie Kay again, aren't there similarities between AI machines ingesting and storing works and search engines indexing and storing or caching copies on its servers? Interesting.
Some technological similarities, but with the search engines, you don't have the possibility of the creation of new works. They're using it for a different purpose, but yes, some similarities certainly in terms of the technological process.
Yes,
and the copyright significant acts of reproduction.
Yes, I think that's right. And it also gives rise to slightly different economic considerations as to what one wants to do about that sort of situation. Because if, for example, there's been an ingestion of and storing of works and a new work is created as a result, which is then very successful, one might say, well, there might be some justification for remuneration rights in those in that kind of context, but they may be a different sort from those which rely on simply having particular works available in an index. So I think one would need to tailor a solution. There's a great risk in this area, I think, of looking at copyright, looking at any given right and saying, right, because we've got this right that works well for this particular technology, it must be implemented in exactly the same way for a different one or a different market context. That's one of the reasons why, in a way, there is an attraction to the legislative approach, both of Australia and the EU, specifically on the news aspect, because what it takes is a very specific industry and says, right, we're going to provide for rights in this industry in this way and address a particular problem. What one might say, it's a very stationer's company way of working, because that's really the origin of copyright, addressing a very specific problem in a very specific way. And you were all at the heart of it. That is a way I think that works quite successfully.
Yeah, it may also be worth adding that there's a difference, again, from a US perspective in terms of the fair use analysis of these very different kinds of activities.
So I think we've got time for one more question. Andrew Hughes has written, given Google and Facebook are seeking to buy off financially desperate news publishers with deals that include commitments that they do not lobby for better solutions, and in Facebook's case, switching off Australia to get better terms, isn't this proof that Google, worth $180 billion per annum, and Facebook simply have too much power and need to be broken up? That's a very different question. They have been described elsewhere as overmighty. I wonder if you want to make any comment on that. It's not strictly.
It sounds like a rhetorical question to me.
It probably is, yes, indeed. So I think we're now at the end of our time, and so I'd just like to thank both Shira and Daniel for a really interesting discussion on some of these huge issues that are facing us, and it's going to be interesting to see in a couple of years' time where things have moved to, not just in the US and the UK, but all around the world. I get the sense things really are moving at the moment. So a good time for copyright. So thank you both very much indeed, and thank you to all of those of you who've listened and stayed the course, and I hope you've enjoyed the session. And anyone who would like to know more about the Stationers Company, don't forget to visit the stationers.org website to see what other events are going on and how else you might be able to be involved. So thank you all very much indeed. We'll say farewell.
Thank
you very much, Sarah, for great moderation and for inviting us.
My pleasure.
You're here. Thank you.
Thank you both. Thank you both.